Subscribe to our YouTube channel and don't forget to press the bell icon to get all the latest updates. In a case that will be widely scrutinized and widely debated, senior advocate and political leader Prashant Bhushan has been found guilty of contempt of court by a three-judge bench of the Supreme Court. The Supreme Court says that Mr. Bhushan is guilty of false and malicious tweets that have lowered the public's faith in the judiciary. Now, the sentence could range from a few months' imprisonment to a fine of 2,000 rupees or possibly both. It will be pronounced on the 20th of August. But coming on the eve of Independence Day, it's a verdict that is likely to raise very, very deep and fundamental questions. Has the judiciary overreacted with this verdict? Has it in fact lowered its own stature? Or has this been a commensurate verdict? Remember, it was the Chief Justice, Justice Bobde, who was the subject of Mr. Bhushan's tweets, at least one of his two tweets. Joining us on the program now, we are joined by Yogendra Yadav. Yogendra Yadav is, of course, a politician and a compatriot, as it were, of Prashant Bhushan. We're also joined by Vivek Reddy, who's a lawyer and a BJP-leaning supporter and political voice. And we're joined by Sanjay Hegde, senior advocate of the Supreme Court. Yogendra Yadav, I'll start with you. Naturally, you will feel that what has happened with Prashant Bhushan is not fair. But in its 108-page judgment, that's right, 108-page judgment, the Supreme Court says that while individual criticism of individual judges is permissible, this is something that lowers the very faith that the people have in the judiciary, and it cannot be allowed.
Barkha, you are an analyst, you are an observer, you are a woman. If the Chief Justice of the Supreme Court holds a special hearing on Saturday on question of sexual misconduct, harassment against himself, sits in the court, who is lowering the dignity of the Supreme Court? You who talk about it, I who talk about it, or the judge who does something of this kind? To my mind, what has happened today is ADM Jabalpur Part 1. This is Scene 1 of ADM Jabalpur. We would see Scene 2 on the 17th, Scene 3 on the 20th. What has happened today was not unexpected. The interesting thing about the judgments are the following. A, it does not answer the legal questions that Prashant Bhushan had posed. You remember last week after the hearing, Prashant Bhushan had filed a petition saying, I am entitled to a personal hearing because I was not supplied a copy of the petition on the basis of which you've done it. He had cited a Supreme Court judgment. Today's judgment does not refer to it. There were petitions about impleadment. Today's judgment does not say a word about that. There were technical questions of various kinds which are not addressed, but I'm sure Vivek and Sanjay are much better qualified than I am to answer that. But what else does the court say today? The court basically says that we don't have to prove that what you did obstructed justice. We don't have to get into that. If we feel that what you did lowers the dignity of the court, that's enough. I don't need to give any evidence of the damage that Prashant Bhushan may have caused. And number two, while the court goes out of its way to say that tweet number 1, the motorcycle tweet, was false, it does not even get into the question of whether the second tweet was false. Because if you remember, what Prashant Bhushan said in the second tweet is something which the 4 judges of the Supreme Court had themselves said. So they were not causing contempt of court. Prashant Bhushan, who repeats what they were saying, was causing the indignity of the Supreme Court. And the last thing, Barkha, to my mind, the larger question that comes up, more than the constitutional legal questions, is the Supreme Court above any criticism? Suppose there was a moment, let's say today we have wonderful judges, great judge, and it's only Prashant Bhushan who is the problem. Tomorrow, suppose we have a Supreme Court. Suppose in that hypothetical situation, the CJIs are sold out to the government. So naturally, in that case, there would be no cause for the parliament going for impeachment proceedings. Can the public of India not even question? Can they not even be criticized? That is what the Supreme Court is telling me, and that's dangerous for democracy coming on the eve of Independence Day.
I just want to briefly ask you whether it's with full sense of responsibility that you compared this verdict to the caving in of the judiciary when it came to the emergency, because that is the Jabalpur judgment that you refer to, point one. Point two, Mr. Bhushan's second tweet did make a more generalized comment on the previous four Chief Justices as distinct from his first tweet, which was regarding Chief Justice Bobde and a motorcycle that was stationary. And Prashant withdrew part of that tweet because he said, oh, the helmet was not needed because the motorcycle was stationary. That particular tweet, which basically was more broad-based in its criticism of four Chief Justices, do you as a member of Prashant Bhushan's party stand by that tweet? Do you support it? And if so, you might face contempt of court next.
Barkha, it is with full responsibility, full seriousness, and willingness to take legal consequences that I say, I repeat what Prashant Bhushan said in his tweet about the decline of the threat to democracy in the country, role of the Supreme Court in general, and the sad role of the four Chief Justices. Prashant Bhushan did not just tweet. He then submitted more than 100-page affidavit, speaking in each single case of conduct which brought the reputation of the judiciary down. Prashant Bhushan does not talk of corruption in the case of these four judges. He says their conduct is such that it brings the reputation of the judiciary down. And this is not just Prashant Bhushan. Hundreds of people who have commented on Indian judiciary. You can find dozens of editorials. You can pick up all the fine minds writing on Indian judiciary inside the country and outside the country. Everyone thinks so. And I definitely do believe that if emergency was the lowest point for Indian judiciary, incidentally, today's judgment says emergency was a dark period for Indian democracy. And I really want to thank the judges for saying so. Probably for the first time, Indian Supreme Court has said that. What we are witnessing is something very similar. And if I may say so, today's judgment has actually proven what Prashant Bhushan was implying.
Vivek Reddy, in its 108-page judgment on these two tweets, and I do emphasize the number of pages because some may say, really, does the Supreme Court need to spend so much time on two tweets? Let's say these two tweets are irresponsible. Let's say these two tweets are untrue, for argument's sake. Every single day, things are said about each one of us in public life, in professional life. And we learn to ignore them. We say we're being trolled. Sometimes we feel bad. Sometimes we argue. When they're very defamatory, we go to court. But here you have something called contempt of court, which may be perceived as a court being above criticism. The court says it will not comment on the part of Prashant Bhushan's tweet, which talks about the weakening of democracy, because it says it does not want to get into a political debate. But it calls the rest of the tweets false, malicious, scurrilous, and lowering the stature of the Supreme Court. What has lowered the stature of the Supreme Court, this verdict or the tweets?
Well, I think the two offensive parts of Mr. Prashant Bhushan's tweets were seriously considered by the court, not all the entire portions of the tweet. Unless we have a focus on those offensive parts, I don't think this debate can move on in the right perspective. The first offensive part is, Yogendra didn't point it out, the first offensive part is what the court called patently false, that the court was in lockdown. I think the court held him for this because the court was not in lockdown. There were video conferences. Prashant Bhushan was painting a picture that there was a total lockdown of the court. The Supreme Court was violating the fundamental rights of citizens and it was not hearing matters and it had simply shut its doors while the CJI was going about in bikes. Well, this was corrected by the Supreme Court factually in its finding when it said that 879 sittings had been undertaken during the lockdown on video conferences and the court had heard 12,748 matters and 686 of them related to fundamental rights under Article 32. So therefore the court said that this is patently false and there was no necessity for Prashant Bhushan to have made it. Now the larger abrogation of the contempt jurisdiction occurred when Prashant Bhushan said that democracy since the past 6 years has been substantially torn apart, destroyed in India through the Supreme Court. I think this is where each individual perception, Barkha, you may have a perception like, look here, there is democracy that is violated. I may have a perception that democracy is upheld. There is an elected government here that is running since the past 6 years. So therefore, nobody is entitled to say that the Supreme Court as an institution has eroded democracy or completely destroyed democracy in India. This personal view of Prashant Bhushan offends the institution, and this cannot be. This is scurrilous and scandalous, and this is malicious. That is why the Supreme Court said that, look here, this cannot be accepted at all. And the 108-page judgments, the whole judgment does not talk about the two tweets. It talks about the questions of law. Various judgments have been cited by Dushyant Dave. Those judgments have been considered. As a responsible court, it has to consider those judgments and give a finding. But one thing I'd like to say, somebody said, Yogendra said, this is ADM Jabalpur 1, there is an emergency. Well, my friend, Mr. Yogendra Yadav, I hold you in repute for various things because you're a thinker, you're a writer, and you're a political activist. But let me tell you one thing. This is an elected government that is there, and there is no emergency. Why are you harping like scarecrows and repeatedly saying that, look here, there is an emergency, there is an emergency.
What Prashant Bhushan tweet
this
says
is patently false. And I have seen many people
let me get
become very adventurous.
Let me get Sanjay.
Let me just, one last point, Badarka. I have seen the people getting so frustrated with the present Modi regime, some people getting so frustrated with the Modi regime. Well, you are entitled to be frustrated, you're entitled to dissent. But the frustration is taken out so much on the tweets that they are ready to be adventurers and ready to say, look here, I have this heroism to go to jail.
Before you get...
Yogendra Yadav wants that also.
At least you're conceding that ironically there might be heroism in the consequences, which is always the irony. Which is always sometimes the irony.
Sheer adventurism.
Okay. Yogendra, I'm sure we'll have a response to that, but I must get Sanjay Hegde first. Sanjay Hegde, this will have a consequence on how lawyers, in particular younger lawyers, actually respond in court, function in court. You've commented on that. Do you want to come in on the larger point of the law? There are those who believe the contempt of court per se is an archaic law, one of our many archaic laws that needs to go.
Well, it is certainly archaic, and scandalizing the court is something which is almost sounds Victorian. At least 30 years ago, when the House of Lords gave a judgment in the Spycatcher case, the Daily Mirror published the photographs of the judges upside down with the headline, "You fools." And that was not taken to be contempt. The basic idea in a free society is that the answer to a speech is another speech. And we live in a free marketplace of ideas.
Yeah.
That was Justice Holmes in a judgment called US versus Abrams, where we now get into a position where there is only approved speech and the rest is contemptuous, it is seditious, it is anti-national. Then we do not live in a free society. I am very sorry to say it, that an institution that I love, an institution that I've worked in throughout my working life, has now gone to the extent of saying that thou shalt not speak. If you slip by ever so much, it will be contempt. The basis of this judgment is, look, Prashant Bhushan says this is wrong, this is wrong, this is wrong. And anyway, Prashant Bhushan, being an officer of this court, being a lawyer for 30 years, ought to know better. We are looking at the context of it being Prashant Bhushan's tweets. If anybody else had said it, maybe we would have shrugged our shoulders. That seems to be the inarticulate major premise there. But because Prashant Bhushan has said it, we cannot remain silent, and we need to deal with it with an iron hand. These words, the phrase iron hand comes not from my imagination, but from the judgment itself.
Yeah.
So what is the message that they are giving the lawyers of this country? That do not speak too much, do not speak out of turn, lest we decide that you are in contempt, or that you will no longer be given a long enough audience. My respectful submission is simply this, that judges don't fall from heaven. Judges are merely lawyers who have accepted a job of judging.
Okay.
If you do not have a strong bar, you will not have a strong judiciary.
Okay, let me get
And
Vivek
that's the
ready.
end of freedom.
Vivek, briefly, and then Yogendra Yadav can take both the points. Yeah.
Yes. I think one fallacy in what Sanjay Hegde proposes is that the contempt of court jurisdiction emerges from the Constitution, not from the Contempt of Courts Act. Rightly or wrongly, our framers decided that the courts must have this jurisdiction in order to rein in certain elements or certain miscreants who abuse the court. I think this is a very essential power in an Indian context. Sanjay Hegde may be talking about England. England is a totally different democracy, and India is a totally different democracy. But in a situation where
You're repeating Churchill.
a person says that judges have a role in destruction of democracy, it is an attack on the institution. It is an abuse. It is an incitement to have doubts against the institution, to denigrate the court, which the people of India, that impression carries to the people of India, to the public in general. I think that is where the linkages are very clear. And Prashant Bhushan should not have done it out of frustration or out of Twitter ranting or whatever.
Let me put this to Yogendra Yadav. Yogendra Yadav, there are two separate aspects to this debate. One can agree or disagree with Prashant Bhushan, his choice of words, his articulation, and one can disagree with the Supreme Court's response to it. Actually, you can have the freedom in this country to disagree with both. That is what a democracy should be about. Do you today stand in defense of what Prashant Bhushan said, or do you today stand in opposition to what the court has done? Because both might be separate debates, and one needs, I think, more emphasis than the other.
It so happens, Barkha, that in this instance, I happen to say both. Because there's so much emphasis on choice of words, let me just repeat the words, which, as I said, I do it with full responsibility. When historians in future look back at the last 6 years to see how democracy has been destroyed in India, even without a formal emergence. That's the first part. Supreme Court says, we don't need to get into that. Fair enough. Incidentally, it also responds to Vivek Reddy because he says, even without formal emergence. Now, imagine, Barkha, you writing a book, and I hope you do write a book on the history of Indian democracy. Then historians, they will particularly mark the role of Supreme Court in this destruction, and more particularly the role of the last 4 CJIs. My question normally to Barkha that would have been, Barkha, would you not mark this if you write a history of this kind? Will I not mark it if I get a chance to write about it? To my mind, what Prashant Bhushan said was not only permissible under law, it was desirable to strengthen our democracy. And in a critical moment of this kind, it was Prashant Bhushan's dharma to speak what he did. This is the dharma to defend democracy. I salute Prashant Bhushan. And to my mind, Vivek Reddy is right in one respect, I must say. England is a different democracy. India is a different democracy. And Vivek, when you say that, you put Indian democracy in a very, very poor light. I wanted you to be more nationalist than that.
Okay, Vivek can take that swipe in a moment. Sanjay Hegde, I have a question. On social media today, people have pulled out an old comment by Prashant Bhushan, where he does in fact defend a contempt of court judgment by the court. So Prashant Bhushan clearly per se is not against contempt. I by the way, per se am against contempt of court. I have a huge problem with some of these laws in themselves, because I think that just like the media, the court should also be able to take unflattering opinions on its chin. But Mr. Bhushan's old tweet is now doing the rounds. I'm sure you've seen it as well. Does that weaken his case in any way?
No. That incident and that conviction related to a former judge, ironically. Yeah. And the judge had done his best to derail the process of justice in the High Court and even subsequently. So, well, contempt per se, Prashant Bhushan, in that particular case, Prashant Bhushan said that was all right.
Yeah.
Today, we are speaking of a much larger debate. And Prashant Bhushan, it's nobody's case that Prashant Bhushan has done what Justice Karnan did. Prashant Bhushan has just tweeted one portrait of the Chief Justice on a bike and his opinion on what history might say. Now, I have an opinion on what history might say. It comes from Dinkar. Dinkar said, समर शेष है, नहीं पाप का भागी केवल व्याध, जो तटस्थ रहे, समय लिखेगा उनका भी अपराध. That those who sat silently, history will write about their offense as well. And the Supreme Court is not just this one bench. The Supreme Court is an institution of 30-odd judges and nearly 3,000 active lawyers. Those of us who remain silent, people will be right to be in contempt of us too.
Okay. I need to take last comments. And Vivek Reddy, here is my question to you. You quoted from the judgment to talk about the number of sittings that the Supreme Court had held during the lockdown to say that Prashant Bhushan, in fact, made an untrue comment. Fair enough. But there are many critical points involving issues of the Constitution. The habeas corpus petitions, for example, related to Jammu and Kashmir, which just were not shown the same urgency. And in contrast to that, the speed with which the court has acted on a matter that relates to itself is unmissable, wouldn't you think?
Well, I think rightly so. Rightly so because of two reasons. First of all, Jammu and Kashmir was a matter of internal security. The government had told the Supreme Court that this is necessary to maintain law and order and internal security. Therefore, there was no urgency shown. You had to maintain that law and order. You could not have court interference. This was a totally different situation. It was not a habeas corpus case per se. It was how to ensure that Jammu and Kashmir integrates with India. That was the question. Now here, the court had to show that urgency because it was a challenge to the institution, an attack on the institution.
What would have happened?
It also said...
Vivek, what would have happened to the court? अगर ये केस 1 महीने 2 महीने बाद आ जाता तो कोर्ट क्या less powerful हो जाता? क्या होता?
Let me tell you one thing. No. Let me tell you one thing. As fast as people of this country are removed from the mocking gestures against the judiciary, the better it is. Because it incites people to lose faith in the judiciary by scandalous statements. This is number one. The second issue is, therefore, the urgency. The second issue is, who are Sanjay Hegde, Yogendra Yadav to become writers of history at this stage? I mean, free speech gives us that right. But why do you drag an institution? Why do you say that this institution caused this democratic destruction? Well, why do you put the court there? I don't think the court is responsible. You may have various perceptions. And the very fundamental thing is, your whole perception that democracy is destroyed is itself wrong. This is a basic fallacy. And like scarecrows, since Modi ji came from the first year, you have become biggest scarecrows of India, saying democracy is destroyed, emergency has come. Well, where is that emergency, my friend?
Barka, I need a quick line.
And so far as English democracy is concerned, let me tell you, English democracy also has its own threats, like Prashant Bhushan threats. And Indian democracy also has those threats. Of course, Prashant Bhushan had recommended breakage of India by saying if people don't want Kashmir, give it to them, let it break from India. Even this is on record.
Okay, here is my question to Yogendra Yadav and Sanjay Hegde. Closing comments. Yogendra Yadav, there is a factual listing of the number of sittings that the court had, which Vivek quoted, to make the argument that Prashant Bhushan was implying a non-urgent intervention by the Supreme Court on key issues. And that was factually not true, question 1. Question 2, you have often gone beyond the conventional, formulaic, left-of-center thinking to try and identify where the pulse of the nation, the pulse of the public lies. Do you believe today that the pulse of the public lies with the Supreme Court verdict or against it?
Barka, the question of pulse of public is very central to democracy. But the institution of judiciary is there precisely if needed to go against pulse of the public. Judiciary exists in democracy precisely because if it is the right of one individual against 130 crore people, it should be defended. So in the question of judiciary, we should not. And I'm afraid it is precisely perhaps the pulse of the public which is playing so much in the minds of much of the discussion. I'm afraid like the previous time, my friend Vivek Reddy has let the cat out of bag. He says The Supreme Court did not pick up some of the cases because of a substantive reading the Supreme Court had about that. Kashmir, because of national security. I'm sure he would give me a very good reason why Supreme Court has not heard the electoral bond petition. A very lovely political reason why Supreme Court has not heard the challenge to CAA. So he's implying, I'm not, that these are not procedural problems of too many cases. Supreme Court is applying its mind about which cases to be heard first and which to be withheld. That may be contempt of Supreme Court. Vivek, just be careful. Be careful about these things because now there is
not at all. Come on.
Contempt of court
I
question.
think you're in contempt already.
Contempt of court question.
Yogendra, you're in contempt already and you're willing to face it.
I do think contempt of court legislation is required because if there is actual obstruction of justice, here is a state which says, I shall not obey the order of the Supreme Court. Yes, the Supreme Court needs to do something about it, but it is not to say, oh, I'm feeling offended. Oh, I'm feeling scandalized. Oh, you've lowered my reputation. Sir, look into everyone's eyes for your reputation. If you do great work, no one in this country is going to listen
just
to
a one-liner.
Why would anybody even look at us?
One-liner.
Okay, Vivek, one line and Sanjay gets the closing word.
Yes.
One line and Sanjay gets the closing word.
I don't think the Supreme Court should set its timetable to the urgency and calendar of Yogendra Yadav.
Certainly.
I think constitutional matters like CAA and electoral bonds require larger benches, and those larger benches will have to decide it. But here is a case where there is a 3-judge bench which has decided it. Please don't set your calendars to match the Supreme Court. Supreme Court has a different calendar.
Sanjay, what do you expect the bar associations to do next?
Well, if the bar associations don't stand up, then they will fall for everything. But the bar associations will be just one more institution that have failed to stand up in difficult times. Ultimately, in difficult times, those who stand up, they will be counted. Otherwise, the pillars will fall by themselves.
Okay. This is not a debate about an individual. It is actually a debate about our institutions. And that is why it is a critical conversation. And I hope we're able to have it with honesty, without shrillness, and in fact, keeping politics aside. Because today what impacts one person can impact someone on the other side tomorrow. With the same ferocity. And I think that's what's important to remember. We leave it there. On the 20th, we will revisit this conversation. And in the days to come, Vivek Reddy, Yogendra Yadav, and Sanjay Hegde. Thank you so much.
Thank you.